Afternoon, everyone. This is Sean Timmons with Tully Rinke here in Houston, Texas, along with my colleague Allison Weber. We're going to go ahead and get our presentation started. I appreciate everyone joining. Today, we're going to discuss your rights against self-incrimination in the military, understanding your Article 31 rights under the Uniform Code of Military Justice, along with the Fifth Amendment to the Constitution. Today, I'm joined by my partner and colleague Allison Weber from our Buffalo, New York office. Both myself and Allison are former uniformed Army judge advocates, and we both served at the rank of captain, and we have substantial trial experience between the two of us. We cover the globe handling court-martials and administrative separations around the world. Allison's been to Alaska and all over the world, and so have I. So whether it's in England or Hawaii or South Korea or anywhere, spin the globe around, we've been there. We've handled cases, and we represent clients actively with no limit to our capacity to handle military cases. Both former judge advocates, both went through officer basic course with the U.S. Army, both served in active duty for several years. I believe Allison served a bit longer as a judge advocate than I did. I've been in private practice now for 13 years, and about me, I run the Houston office of Tully Rinke PLC as a managing partner. That means I'm responsible for the day-to-day activity of the Houston team. I'm also managing a lot of associates under my supervision and direction across multiple practice areas. I have a practice, four-legged horse practice. I would describe it as: one, do court-martials; two, administrative separations; three, a lot of ROTC and service academy representation and defense; and then four, a bunch of civil matters for reservists and guardsmen and active members of the military who have USERRA issues. USERRA is the Uniformed Services Employment Reemployment Rights Act. So today we're going to primarily talk about what results in ultimately court-martials, and sometimes the command is, not inclined to prosecute, administrative separations resulting from self-incrimination. And that's about me. I'm going to turn it over to Allison to go ahead and introduce herself. If you want to learn more about me, I encourage you to read my bio and Google me and read more about some cases. But anyway, I've been handling cases in private practice now for 13 years. I've been an attorney for over 17 years, and I have dozens and dozens of court-martial case experience under my belt in civilian practice, having handled trials in every branch of service. I'll let Allison go now. Thank you.
Hi, everyone. Welcome. Sean pretty much covered most things. I am a former uniform judge advocate and served in Korea, North Carolina, and Germany. I have gone a number of places since then to travel for Tully Rinke and represent clients, Alaska being one of the most interesting, having to go repeatedly. But yes, I've been doing this at Tully Rinke since 2018, and prior to that I had done another 7 years in the Army. So pretty much all of my experience over the past 14 years has been military related, and my focus goes across from whether it's criminal law separations to discharge upgrades, but more often than not I end up in the medical board process or line of duty actions. So we split up our actions across the practice group quite a bit, but inevitably military justice is always going to be in there, whether it's courts martial, separation actions, or Article 15's, letters of reprimand, things like that. So all of this is going to be relevant. Well, not all of my background, but the Article 31 rights and Fifth Amendment applies to a lot of areas, and it's important for everyone to understand what the rights are in advance so that you don't get taken advantage of and ruin all your chances for your military career. So in any event, I'll turn it back over to Sean to get the presentation started.
Okay, well, thank you, Allison. Appreciate that. Me and Allison have worked on a lot of trials together. In fact, when Allison joined our law firm in 2018, she was one of the associates that was instrumental in my success at prior court-martial cases. I believe she helped me out in New Jersey and multiple other jurisdictions. So I'm internally grateful to Allison's contribution to the firm. She's also worked her way up, as I have, starting as an associate, now being a partner. So we both survived multiple years in private practice, which is grueling. I will say private practice is not something that the average attorney can necessarily withstand. You have to have a little bit of grit. You have to have a little bit more backbone. You have to have a lot of perseverance and a lot of fortitude and a lot of energy, and you have to have fire in the gut. If you don't have that fire in the belly, you're going to go back and work for the government, because without that fire in the belly, it's really hard to get through the day-to-day injustice we encounter, and continue to try to go forward without being, cynical and depressed about the circumstances you find yourself in for your clients. Let's talk about now some generic advice. As we all know, if you're facing investigative inquiry, it's beneficial to be silent, not to participate actively in the government's attempt to gather information. That doesn't mean you actively destroy evidence, but what it does mean is you don't affirmatively talk to them to corroborate the story or provide information they can use against you that would say you're lying. So let's talk about the Fifth Amendment right now, the first slide. The Fifth Amendment says, and again, this is different than the law of England at the time. The king could summon you to talk, and if you don't speak, cut your head off. And that literally happened in human history, and especially in the English common law history. The United States, when we founded our Constitution in 1787, one of the key amendments, the Bill of Rights, was the fifth, which said we're not going to have a leader, a king or a president or anybody summon you to provide information adverse to your own livelihood, to where if you confess, you are disposed of, and if you don't confess, you're still disposed of. You have an absolute right to say nothing, and no liberty shall be taken from you. If your land is taken, the government owes you compensation for the fair market value. That's called eminent domain. So the government can take your property, they have to pay you for it. But they can't make you talk against your free will, and they can't make you provide information that'll harm you if it's going to cause you to expose yourself to liability. So if you're ordered to testify, but through subpoena, they can certainly summon you to appear. But if they're asking you questions that are going to incriminate you, you have every right to say, pursuant to the Fifth Amendment, I choose not to testify. Now, they can still ask you 100 questions, and you can just respond to each question. Fifth Amendment, I'm not going to talk, thank you, and then move on. And you see that with some of the mob hearings and Hollywood productions, and that's an accurate utilization of the Fifth Amendment. There's also immunized discussions where you have an absolute right to privilege. So communications between your spouse, husband, wife, or vice versa, if you, or husband, whatever, but marital spousal privilege applies. What that means is if you're married to somebody and you're talking, there's no liability for your communications. Generally, if you talk to a random person on the street and solicit them to rob a bank, you're now guilty of solicitation of a felony, and you're guilty potentially of conspiracy if the two of you agree to go rob the bank. If you're talking with your spouse and you talk about robbing the bank, you're not engaged necessarily in solicitation of a felony or conspiracy to commit a felony. You are just engaged in marital banter, and the public policy behind that is to encourage marriages to talk each other out of stupid ideas, such as engaging in a future bank robbery to pay the bills. Don't do that kind of thing, and if you're talking about it amongst yourselves, you don't have to disclose it. In fact, the marital privilege applies to the Fifth Amendment because you can compel your spouse not to incriminate you, and if they do, there's liability associated with that. So similar to attorney-client privilege, tell your attorney anything you need to tell them. There are exceptions to the attorney disclosure requirements for safety purposes in certain jurisdictions. So and the future crime exclusion, you can't go to your attorney and ask for advice about how to commit a future crime. You can only talk to your attorney and keep confidential prior events. So if you tell your attorney, yeah, I robbed the bank yesterday, please help me out, your attorney's compelled not to disclose that information. If you say to your attorney, well, my plan is to rob the bank tomorrow and hold these hostages, the attorney has a duty to contact the authorities because it's about future activity. The attorney cannot be complicit in committing a crime. So that's a nuanced distinction to keep in mind. Not everything is covered by the Fifth Amendment. The Fifth Amendment covers self-incriminating activity of prior events. So you have plans for the future that you shouldn't discuss and volunteer that information, but others can. And the investigators, OSI, CID, NCIS, FBI, you name the alphabet soup of who's investigating you, their job is to get you to talk. Their job is to incentivize you to speak and make, amorphous promises of benefit if you cooperate. Unless you get written, confirmed immunity, which you need a lawyer to review to confirm its legitimacy, do not voluntarily participate in providing any information. Okay? There's very, very rare exceptions when you talking makes a lot of sense. If you have a foolproof alibi, or identification issue, where you think disclosing your actual identity will show they're looking for the wrong person, that may be a time when you want to volunteer information. So if you have a similar name, your name is Jesus Garcia, and they're looking for Jesus Garcia, and I think they got the right one, and you can show through providing information that, nope, they got the wrong person. I wasn't in Oregon, in Portland on October 3rd. I know I was in Miami, but they're looking for somebody who was in Portland, Oregon, October 3rd. You might, through an attorney, provide that information to corroborate your alibi. So disclosure of an alibi defense might be the one time a Fifth Amendment, not invoking your right against self-incrimination may make sense. Very, very rarely will it make sense otherwise. Because what CID is doing and what NCIS is doing is they have a checklist of elements. And they're looking to see, after they have an accusation against you, and I pull you in to talk to you, if you'll back up what's been said. So, for example, the CID, while you're providing information, is checking off boxes. Oh, so you do know Miss Smith. Great. And you did have dinner with her, right? Okay, great. And you bought her alcohol. Great. And you went to the hotel room with Miss Smith. Great. So you've just corroborated everything about the story up to the point of consent versus non-consent. They have very little work to do. In fact, they have their whole case for them. You can go in there and be like, yeah, I bought her dinner. Yeah, I took her to my hotel room. And yeah, everything had happened was totally 100% consensual. But she's already reported that to them that you committed a violation against the statute by engaging in, activity where she was incapacitated. And you just confirmed in your discussion, yeah, I bought her alcohol, of course. I had alcohol too. You just basically confessed to the crime. You can't do that. If you do that, you're making the job for the government super easy, and you're likely to get convicted, because by providing that voluntary disclosure information, it's at minimum 50-50 whose story they believe. And they're already halfway there. If her story sounds more credible than yours, you're screwed. If you don't talk, the burden's on the government to go from 50% to 90% plus beyond a reasonable doubt, which is why communicating information is absolutely not in your best interest. Because again, they're not going to believe what you have to say. You may think they will. You may be a great salesman for selling cars or houses or whatever you've done before, but that's not the intent behind the investigator's disposition. Their job is to believe you're lying, but then use the information you provide from your quote lies to back up what they need to know, that they need to independently corroborate to prove the crime. So don't talk. I can't say that enough, because I'll tell you, the hardest cases I have is where people call me, they've hired me, they want me to represent them after they've already provided information to the investigators, after they've already provided a statement, they've already basically confessed, or they've responded to a pretextual phone call confession where they were asked to apologize and they apologized for what they're being accused of, and now it's independently corroborated. So if somebody calls you and wants you to apologize for a crime, hang up, because you're probably being recorded. And just hang up, provide nothing. If you provide anything at all, just say, please do not contact me ever again, hang up. But that's all you need to say. Beyond that, you're opening yourself up to exposure and liability. So doing the webinar here, because I've got a long history of horror stories. People who've hired me want me to fix up their situation, but they've already got a 30-yard penalty on their case right away. So we're first and 40 before we start. Not first and 10. We're already starting 5-0 in a baseball game. However you want to analogize it, we're starting at a significant disadvantage. Imagine starting a football game down 27-0 in the third quarter. If you talk, that's the hole you're digging yourself into. Is it insurmountable? Not necessarily. I mean, people come back from 27-0 occasionally. People win baseball games down 5-0 sometimes. And we have the team to put together the force necessary to try to accomplish that. But it's a lot easier if we start at a fair 0-0 score. And the only way that starts for your case is if you don't talk. So I hope I beat that to death and everybody understands why it's so imperative. I can think of 100 different analogies to use, but sports sometimes, especially because, honestly, most of my clients in the military are men. Most men watch sports. Women watch sports too, but sports analogies are just very, very illustrative of the serious damage you can do by talking. And it's not human nature. Human nature is to go explain yourself and let the process go away. With the investigators after you in the military, you're in big trouble. Same with the command. You may feel compelled because your commander is asking you questions to respond. You have absolute right to say, sir, ma'am, I'm not providing any information pursuant to my rights under Article 31 of the UCMJ. All stop. They keep talking to you. Just keep saying the same thing like you're a prisoner of war. Remember your prisoner of war training, your name, rank, serial number, date of birth, home address. Provide beyond that, you're opening yourself to exposure. So don't do it. Next slide. Article 31, basically, Article 31 codifies the Fifth Amendment. And it says every member of the military is subject to complying with the Uniform Code of Military Justice. So if a commander forces you under duress to talk in violation of Article 31, that information is inadmissible. But there has to be serious duress there. You can't just use basic persuasion. That's not going to be duress. When I say duress, I mean like I put a gun to your head, or they deprive you of water for 10 hours, or they literally torture you with waterboarding. If you talk under those circumstances, understandable because you're trying to avoid torture, that's going to be inadmissible because Article 31 says you cannot be compelled to provide information, and you cannot be compelled to provide information intended to degrade you, humiliate you, and no use of coercion or unlawful influence or inducement may result in use talking. So if they try to coerce you, if they try to use unlawful inducement, that would be considered inadmissible. We fight this issue a lot because people will talk to CID for 7 hours with no water and no food, and they start losing their faculties, and their chemicals are all off because they haven't had their medication, they haven't had their blood sugars off, and they start talking. You might be able to get information suppressed, but it's best just to not let them put you in a position where you've been there for 7 hours. Just tell them immediately until you're blue in the face, I'm not speaking, and sign whatever they make you sign, and they should leave you alone. If they want to, put you in jail, they can probably do that if they have authority to do so from a magistrate, but you still shouldn't talk. Don't speak. They might offer, inducements and benefits if you do speak. Don't take it. Don't drink the Kool-Aid. Don't eat the donut. Don't drink the coffee. Just tell them again and again and again, I'm not speaking. I have nothing to offer. Fifth Amendment, Article 31, I want my lawyer. That's all you need to say. If you say beyond that, again, you're exposing yourself. So the reference to that is the right against self-incrimination under the Fifth Amendment, and then it's codified in Article 31 of the UCMJ. So that's my personal editorial. I'm going to turn it over now to my colleague Allison, who's going to share some of her insight and wisdom. I'm a little bit, hammering this because, again, I've been horrified by the fact that people come to me with real terrible facts, and if they had just not said anything, their life would still be fruitful. Said they're serving long prison sentences. Their life is pretty much effectively, cut short significantly, simply because they dug themselves a hole they shouldn't have dug. So don't drive the car in the ditch deliberately. Don't provide information voluntarily. Just don't do it. There's never really a good excuse. If there is, you've been given immunity, or you've consulted with an attorney first, and you're providing substantial alibi explanation to help identify the actual perpetrator. But if you've done something that you may have liability for, which everybody has liability for a lot of different things you might not even realize, it's best just not to respond with any information. And I know CID agents, I know OSI agents, I know police officers, and I know FBI will absolutely hate me for saying this, but it's true. Their job and their financial compensation is tied to a performance metric associated with how they can get you to confess and talk. And some of them are really, really good at it. They'll be your pal, they'll be your buddy. They will be as friendly as possible to you. They are not your friend. They are the quote unquote enemy. and their job is specifically to deceive you and use deception. And again, the regulation allows them to lie to you. They are allowed to tell you false stuff just to get you to confess what they think you may have done. So you can't trust anything they say.
And actually picking up where Sean just left off, they are absolutely allowed to lie to you. This is a common thing, again, as Sean said, when a soldier comes in, whether it was when we were in uniform or now, and says, well, they told me this, they can't do that. That's not true. They're allowed to lie to you in order to trick you. Now, there are certain things they can't lie about, but they're very limited. So outside of, lying about your right to an attorney, for instance, they can't lie about that, but they can lie about a number of things. And if you look at the slide here, we'll get you a deal. I'll talk to the prosecutor on your behalf. I mean, that could be the truth, but it might be a lie too. One of my favorites is this is your last chance to come clean. Okay. Anytime someone says it's your last chance to speak, that's not true. I mean, everybody should notice that that's a lie, but no one seems to. They think, oh my God, if I don't tell my story now, then I'm boxed in and this is going to happen. So when it comes down to military cases, especially, as Sean said, if you start talking, even if you think you did nothing wrong, you're going back yard by yard. I do like the football analogy. Every time you say something, because it proves one piece of the puzzle. It might not be an important piece, but the more things that you say that line up with the accuser's story, the more it makes them look credible. So you're just ultimately setting the stage for, hey, we both agree up to this point, and now it's like, but who's credible? And you're at the disadvantage because you're the accused. Everything's painted in a way that makes it seem that you're the one at fault. So it's never going to be your last chance to come clean to tell your story. Okay. The last chance for you to tell your story is after you get into a trial. Even then, it's technically not your last chance, but still, I mean, at the end of the day, that would be your option. But what you can say is, if you do want to talk, say you want to, okay, the answer is still, I would like to speak to a lawyer before I talk to you. That is how you can invoke your rights by saying, I don't want to say anything, or you can invoke your rights by saying, I want a lawyer. You can say, I'm open to talking to you, but I want to talk to a lawyer first. And as Sean said, there's very few situations where you actually want to talk or should talk. A lawyer is going to be able to help you identify whether yours is one of those. So there's no harm in taking that extra couple days to speak to an attorney to say, hey, I think I should say XYZ to them because this is what happened. And the lawyer is either going to be like, wow, that's a really bad idea. Like, you should not do that. Or they're going to say, you're right. In this case, that makes sense. Let me prepare you. Let me talk to you. Like, let me make sure you know the good, bad, and other reasons for what you're saying. Because even if it is in your interest, maybe not everything's in your interest. You don't necessarily have to give them, a full autobiography of yourself when you go talk. So at the end of the day, don't fall for the lies, and specifically don't fall for the ones that say this is your only chance. Like, you get no other chances. If you don't tell us what's going on now, you're going to be in a court martial. You can get an attorney in the military or out who can help avoid that situation. CID, NCIS, MPI, any of them, it doesn't really matter. They're really just the first step. And there are a lot of steps between there and an actual trial. So even if you are afraid of the process, that doesn't mean you have to get to a court martial before you're allowed to talk again. That's why speaking to the attorney is going to open up your options, determine whether you should talk, and if you should, when you should talk. There is a lot of strategy that goes on behind the scenes as to when to release information. And you trying to make that decision on your own without going to law school, even if you're a lawyer, you probably shouldn't make the decision on your own. At the end of the day, run it by somebody, sanity check, right? Like, should I be talking? So those are some of the common lies. All of the buddies have confessed. They already told us you did this. It seems very convincing. I mean, again, they're getting paid to lie to you, to trick you. As Sean said, they're getting evaluated on how good they are about getting you to give them information. So they're very good at that. They want you to be loyal to the institution. Like, hey, if you're a good soldier, you wouldn't hide this information. You wouldn't, all of that kind of stuff is they're all different ways to try to trick you into talking. The other thing that comes up is after you invoke, there's only a few questions that they can still ask you. So this is probably a little bit beyond my slide, but either way, if you invoke, if you say, I want an attorney, they can still ask you if you grant them consent to search your car. Just because you ask for an attorney doesn't mean they can't ask you another question about consent of searching, or of, for instance, taking a polygraph. They can ask you that. Although if you haven't given any statement, it's kind of hard to give a polygraph. But like, say you start a story and then stop midway through, if you invoke an attorney, they can still ask you, well, do you want to give a polygraph then? Do you want to take one? Like, that'll get you out. They're allowed to ask that. So just be very careful. No matter how you look at it, it's better to still not say anything, to say no to whatever they're requesting. Talk to an attorney. If it's in your interest, the attorney can call them and go back. The attorney can call them and say, hey, you know what? Actually, this is a good idea. We want to give this to you. There are very few occasions where that makes sense, but you're not going to give up any chances by invoking first. If you tell your story, though, you gave up a lot of chances. And in some cases, maybe you are, again, down 30, whether you're down 30 points, 30 yards, whatever. You might be down 30 points and actually in on the 1 yard line, pretty much on your end, going the other way. Like, hey, wow, you gave them so much information. We have one defense now that's like this good of a chance for it. You don't want to put yourself in that situation. You want to leave it to your attorney to decide what's the best way to go about handling your case. Give them all the options available. The more you talk, the less options you have. So, but the lying part is, in fact, the biggest issue, because they sound friendly. The first thing that these investigators are told to do is to build rapport with you, to make a common connection. Maybe, for instance, talking about sports. You're from here. Do you like, you're from Philly. Do you like the Eagles? Oh yeah, they're such a great, like, they want to make it seem like they're your friends. They want to make it seem like they're there to get the truth. And I mean, they claim they are, but not really. That's not their purpose in this interview. They're going to say, hey, it's in your best interest. Like, they butter you up, they make friends with you, and then they say, like, I can help you out. I can get you the deal. You really, really need to talk to me. Like, it's important. And people will fall for it. Don't let yourself be one of them. Instead, just say, I want to talk to an attorney. And if the attorney says, yeah, it's a good idea, let's go back together and do that statement. That's how you want to handle it. So you're not giving up any chances by invoking first. I guess that's the biggest takeaway. Always start there, because you can always go back and change your mind. But once you open your mouth, you can't take it back. And actually, on that point, I'm kind of going to contradict myself a little bit. Just because your command got in your face and you said something to your command or your NCO or whoever, say somebody questions you before you go to CID, or again, any of the agencies. If your commander didn't read you your rights, got in your face, started screaming at you, or a first sergeant, better example, gets in your face, starts screaming at you, and you say, well, I didn't mean it, I did this, that, and okay. Just because you said it to them doesn't mean it's going to come in, because they didn't read you your rights, right? You have the right to remain silent. If they didn't advise you of your rights, that statement could be suppressed. But a lot of times what people do is they end up going back to CID or NCIS, and oops, they're like, well, I already told my command, so I might as well tell them too. That is the worst idea, because now you're actually boxing yourself into potentially two statements. Instead, you want to rely on the fact that, again, talk to an attorney, find out where to go from there, because they do need to tell you. Like, they're supposed to tell you not only that you have a right not to give a statement, but they should be telling you that you also have a right, if you've previously made statements, that those may not count at all. again, if a commander asks you something and you answer it and you weren't read your rights, that could go away. But again, once you start talking, it might not anymore. So at the end of the day, no matter what, shut your mouth. Just because you've said something somewhere doesn't mean you need to go say it to the law enforcement agency. Talk to the attorney first. Okay, this is probably one of the better examples. Most people go in when they're being questioned. So the most common these days typically are sex assault cases. It's not to say that's the only case, but that is one of the most common. And people will say just about anything to avoid being prosecuted for a sex assault case. And so a lot of times part of what they're trying to do, the agency is trying to get you to admit to something. They read you your rights. You shouldn't talk, but if you chose to, they can not only get you on the original thing that they're investigating for, but anything else that you happen to say. So one of the common ones, using that as an example, people will try to defend themselves against sex assault by saying, look, I'm admitting that I was committing adultery and I was fraternizing and I was doing all of these things that aren't good, but I did not sexually assault them. Well, why did you give them that though? You didn't, there was no benefit for you saying that. In fact, you've just signed your I'm done, my career is over here anyway moment. Now, again, maybe from a tactical standpoint, that would make sense down the line, but you are not in a position when you are being brought in for questioning to know that, to make that decision. So the most common things people get hung up on are either other offenses, maybe they are more minor, maybe again, there's a reason to go that way at some point, but you don't want to do that right off the bat. It's either things that are minor or the potential for a false official statement. That is probably one of the most common offenses that gets tacked on to every case. If you speak, they can come after you and claim you lied. So why not add another charge to your charge sheet, right? Like there's no harm on their end. It's not like they have to pay per charge that they come at you with. They just tack another one on that you lied to the investigator about XYZ. And some things, no matter how much you think you know, I mean, again, everybody has memory failures, I guess you could say. You may think you remember everything perfectly, so you may tell your story. But then when you get brought in 3 months later and go to say something again, no matter how much you knew what happened, you still may say something slightly off. I mean, it's common behavior. And there's nothing wrong with that other than the fact that once you gave a statement, now you can get boxed in for lying. So don't give any opportunity for that to happen. If you're going to give a statement, and again, this is why it's better to do it all at once after speaking to an attorney, you want to make sure that that happens down the line so that you have everything already like squared away. You're confident in your mind. You remember exactly how it went down. You only give it once, other than maybe if you have to testify at the trial. But, again, that's something that your attorney and you will go over to determine how much you want to release and when you want to release, because otherwise you risk getting boxed into another charge. And it's, when we look at cases, we may say we won the case because we got you acquitted of a sex assault charge. But if we come back and you're still convicted of a false official statement, you still have a federal conviction. So talking is what opens you the door for that. We don't want you to do that. I don't know how else to say it. Just don't do it. As Sean beat the horse to death at the beginning, don't do it. There's any number of reasons why it's going to bite you, and it's better to let an attorney help you make that decision up front than to do it on your own. Again, they have to tell you your rights when they intend to question you about things. If they suspect you of something in the military, they have to tell you that they suspect you of an offense. As soon as they suspect you, they got to start talking to you and give you your rights. So that's where, again, it opens your rights up right off the bat. You can never go wrong by saying, I want to go speak to a lawyer first. That is probably the best answer because it puts you at ease to know that you can still go back and talk later if you want to. And it also puts you in a position to have a lawyer give you confident legal advice that, hey, maybe this is a really bad idea. Please do not say anything. So again, those are your rights to shut your mouth, essentially. And it is almost always in your best interest to shut your mouth. But if you are one of those few exceptions, there is still no downside to speaking to an attorney first, because they will make sure to limit any potential exposure for other offenses. And that is where, again, the law enforcement agencies just want convictions. They don't necessarily care about what, they just want to add up the numbers. So you need to protect yourself against everything, even though you don't even know what that is when you walk in the door. That's probably, yeah, a good wrap up. Sean, do you have any points to add on those?
Well, thank you, Allison. I appreciate the opportunity to stretch a 1 minute sentence into a 37-minute presentation, because it really is just one key takeaway. Don't talk to investigators. However, people naturally, human nature, think, no, I'm the exception. My situation is different. And that's why we've taken the last 40 minutes or so approximately to explain why you're not an exception. You're not special. You are special, unique, created by God. I'm not saying, I'm not trying to dehumanize anybody. So don't misquote me. I'm just saying your case, your facts, your situation happens day in, day out. Every day in this country, somebody is murdered. There's 19,000 of them a year. Every day in this country, there are DUIs. Every day in this country, there are rapes. It's a statistical fact. Every day, there's investigators bringing in people for questioning, asking them questions to get them to self-incriminate. All I'm trying to do here is protect those who've sworn an oath to protect us from ruining their life and causing harm to their family and their children, and making themselves unemployable by going in and providing information when they can be given a second chance. I truly feel that my mission in life is to travel the world, case to case, place to place, giving people a second chance. Unlike Quantum Leap, I can't go back in time and reverse what happened, but I can go to the location and help people put their life back together after they made a great mistake. The first thing you can do to fix the grave mistake you may have made is not confess to authorities. Confess that privately to yourself or to your deity. If you believe in God, confess it to God, and keep that between you and Him. Don't talk to the investigators, because they will have no mercy, and they may appreciate you providing your confession, but you're not doing yourself any service. You're actually causing yourself permanent ruin. It's not a good idea to talk and provide information. You have to fight back, and you may not have done anything wrong. In fact, you may truly be falsely accused, or you may have done something wrong, but not what they think you did. And what you did wrong is not even on their radar screen. So when you go and talk, oh, great, so you didn't pay your taxes. Okay, well, thanks for letting us know about that. They didn't call you in about that at all, but you just go in and start talking about stuff, and stuff blurts out, and now they've got a whole new place to look. And that's exactly how a lot of people end up in trouble. So it's best not to provide any information. And I'm trying to be a little entertaining so people, watch the video and get good value out of it, remember what's going on, because you have to, be illustrative so people remember what you're speaking of. We can't just provide a monotone. The Fifth Amendment provides. No, you don't talk, because if you do, you're shooting yourself in the foot. It's not a good idea. And again, this applies in a military context, in a criminal perspective. If your boss for your job wants you to talk about an oil spill, and you may have to discuss the facts of that, because if you want to keep your job. If you're going to go to jail for an issue, you still may not want to say anything, and you get fired, you get fired. So this is not about, necessarily, we can't protect you from all collateral damage associated with being quiet. We can't protect you from is a criminal conviction that'll ruin your life. Because if you're convicted of sex assault, your life is functionally over. You are permanently black tarred with the sex offender registration requirement. You can't travel internationally, and if you do, you have to have special permission. It's hard to get documents. You can't live in most zip codes cleanly without having to live around other sex offenders or in a really undesirable part of town. You can't get most jobs. You can't get credentials. You can't get licenses. Nobody wants anything to do with you. You're stuck, menial work at best if you're even able to do that. So it might have been a mistake when you're 20 years old. The rest of your life now, you're stuck doing, menial occupations with no long-term earnings potential, when truthfully you just made a one-time relationship mistake, and that's it. You didn't necessarily commit a crime. There's a large number of people, and again, this is my own personal editorial. It's not Tully Rinke's opinion. It's not anybody else's opinion other than my own. But a large number of people use information to law enforcement as almost a deflection from their own bad choices, meaning they go talk to the authorities because they want somebody punished for the mistake they themselves feel bad about, but they want to blame somebody else. There's a whole mentality out there that I'm a victim. Yeah, you're a victim of your own dumb choice. Not necessarily the other person that you participated with committed a crime, though. But unfortunately, everybody wants to, point fingers at everybody else. And if you want to respond back, do so through counsel. Don't do so through talking to the investigators. The story, the information the investigators have, is going to be adverse to you. That's why they're calling you in to talk. And by you providing information, you're just backing up elements of what they've already been provided. It's best to say nothing. It's best to just keep your options open and fight back aggressively. And I understand a military senior ranked person starts screaming at you, you're going to feel compelled to respond. Only thing you have to do is remember your prisoner of war training. Treat that as if you're being captured by the enemy, and say nothing other than stuff you're allowed to disclose that they already know: your name, your rank, your serial number, your address, if they need to know where you live. That's it. Beyond that, provide nothing. So if you feel compelled to talk, my name is Sergeant Smith, and my serial number is, and my date of birth is. That's it. Go beyond that, you're screwed. And literally, you're going to be in prison, and you're going to be facing the consequences of that for the rest of your life. So don't put yourself in that position, and don't talk to the investigators to clear the air or provide information. And again, the performance metric of the agents are tied to, so how many quote people did you get to talk? How many of them confessed, and how many of those confessions resulted in convictions? They're graded on all that. Don't make their job easier. Don't provide information voluntarily. And if you're going to talk, do so through counsel and counsel only. And if your attorney tells you to testify, question it. Get a second opinion before you decide to do it. Don't just automatically assume that may be good advice, because truthfully, some attorneys may not give information that's totally legitimate or the best strategy. If you're going to do something as grave as talk, and somebody's telling you to do so, get a second opinion before you decide that's a good idea, because that's how grave of a mistake providing that information can be. Just generally don't do it. And if somebody tells you should, and they're an attorney trying to help you out, I would certainly get a second opinion before you agree to that, and see what the real strategy is, and then triple confirm that's a good way to go forward. Don't just provide that information. Again, that's one of the benefits of having experienced counsel, because you have a brand new trial defense attorney who just got out of law school, never practiced criminal law before, and they've been assigned as your appointed attorney. They might tell you, yeah, let's go talk, make a deal, great. I would question that with the more experienced litigator, because I've seen people trapped by that kind of disposition before, and they didn't know any better. In the end, they were told, well, I was given this attorney, and he's got 7 years of education. I'm 19 years old. Yes, they have 7 years of education, but unless they've been in the trenches, unless they've had actual trial experience, unless they've actually been in the courtrooms, their experience is to be determined. I would seriously question a uniformed attorney's advice, other than just be quiet. If they tell you other things than that, make sure you have experienced counsel walk through everything on your behalf. That's the best thing you can do for yourself, for your livelihood. And again, if you're facing prosecution by the military, that is a break glass in case of emergency type situation in your life. You need to go ahead and pull out all the stops and get qualified counsel. Think of it as heart surgery. Would you want the heart surgeon operating on your heart who just graduated medical school and never done it before? Or would you want the experienced heart surgeon who's done it 1,000 times, who's had 1,000 successful operations, performing that surgery on your heart? Everybody knows the answer to that. You'd want the experience. It's just like a pilot. If you're going to go on a turbulent plane ride, and there's going to be a lot of turbulence and it's going to be scary, Are you going to want the pilot who just graduated flight school? Or are you going to want the more experienced pilot with the gray hair who's done it 1,000 times, who knows what to do? You want somebody with experience who's capable on your team to protect you. So don't just take the assigned appointed attorney and run with it. You certainly want to look at your options to protect yourself because, again, a criminal trial in the military is equivalent to like a brain surgery or a heart surgery. And one little mistake could be the end of your life, quite literally. Or your life continues, but in a whole different setting, meaning Fort Leavenworth for years and years and years, all because you didn't get a qualified attorney who was capable to provide you aggressive advocacy and knows the rules and knows the government's tricks up their sleeve. Because me and Allison both went to all those government prosecution conferences, and they're still using the same Excel talking points today as they did 15 years ago. They still have the same playbook. You want to know what their playbook is. We're giving you some of the inside information here about what they do to get you to confess, and don't fall for the trap. Think about Return of the Jedi when Admiral Akbar screams out, "It's a trap!" If they tell you to come talk to them, it's completely a trap. They are totally trying to set you up, and don't be the gullible person who falls for it. And if you have fallen for it, certainly lawyer up immediately and try to clean it up as fast as possible. And don't beat yourself up over it. It happens to very, very sophisticated professionals who voluntarily believe the nonsense they're told. It happens to everybody. It doesn't matter if you're, grade school education or PhD level. People confess on each spectrum of the economic structure and on the educational graph of credentials. Happens to people all across the board. So don't do it in the military because it's that catastrophic if you do. If you want to contact us, if you have individual questions about if you're facing an investigation from the military, what we can do on your behalf, well, we can certainly provide you representation. We have 22 veterans in our military practice right now. We are the largest law firm in the country with a veteran group doing military law practice. I know of no other military law group as large under one umbrella. Most military law firms have 2 or 3 people outside some installation somewhere, and that's it. And they may partner with 20 other 2 or 3 attorney shops and all collectively be on each other's website. But they're not really working together. It's just a marketing ruse. The reality is Tully Rinke is the gold standard for advocacy and representation when it comes to military, civilian, criminal defense counsel. Myself, Allison, and several of our colleagues, Ernesto, Ira, we all have a large number of trials under our belt, and we've all stood up with our clients when the outcome was not guilty, all charges, all specifications. In fact, I have a prior web presentation on YouTube you can watch called War Stories from Prior Court-Martial Full Acquittals, and what I learned from each of those full acquittals. I highly encourage you to listen to that presentation and all the other presentations Tully Rinke PLC offers and provides on YouTube. We have a wealth of information out there, and you can digest it at your convenience just by searching it through YouTube. I hope you have a great afternoon. Thank you for being here with us today. And if you have any follow-on questions or need to talk with us, you can reach me at my email address is here. Our website is tullylegal.com, and you're welcome to set up an appointment to speak with me to answer any individual questions. Thank you.